feel better when it's all done. And you know, just saying, you know, I would know. Well, we're hoping maybe just a couple hours, not even that. It could be. You know, people may have a lot of questions if they want. Okay. Well, I'm glad you was able to make it. How's your knee today?
many people do we have on Zoom? 25. Great. It's a good crowd. Great. So please feel free to go ahead and continue enjoying this lunch. And thank you so much to Melanie Shawnee for making those arrangements. It was delicious. So thank you. So we're going to go ahead and call the town hall meeting to order. I would like to open with an invocation. Crystal, would you please give the invocation?
Wata, let's pray. Entate wakanta, monshinike, onkoe kue ta die, hombare take ganege. Ganege die, dakte, zane a onkoe ta, ute ata a zani dedo. Hombare kade, itani. Onkoe ta jika kue, dakte onkoe ta, johe kihikas ata. Onkoeta nikashiga data wapide ata wakhe akade data ata abata zane manti zane inkoi onkoe hajon hombade ata manti ata ta de onkoe kini a manti dita ijinke jaje wakanta kakanan. Father God up in heaven, we come to you today to give thanks. Thank you for blessing us upon our endeavors and upon all present today. Forgive us of our shortcomings. Bless our families, our servicemen and women, our business committee, and our nation. May your love and grace continue to guide us in all that we do today and in the future. This we place before in your Son's name, Jesus. Amen.
Amen. Thank you, Crystal. For those who are in the room, all of you, we have copies of this document. It's a Bear v. U.S. frequently asked questions document. If you do not have one, they're back on the table near the entrance. For those on Zoom, the document can be found on both the tribal website as well as the Quapaw Post. So we'll be following along with that. I just have a couple of opening remarks before we get started. So thank you for all the people that are on Zoom, all the people here in this room. It's wonderful to see a broad range of ages. So thank you. Hawaii, thank you for joining this afternoon. The purpose of today's town hall is to share basic Bear v. U.S. case history, the settlement, congressional authorization status, and its current state, to better prepare us all to have a productive Special General Counsel number 3 on September the 30th. The goal is to ensure as many tribal members as possible are able to confidently state their positions at that meeting respectfully and based on facts. Per our governing resolution, our meetings are to follow Robert's Rules of Order. A town hall, however, is more of a discussion. There'll be no need to make motions, and questions or discussion points can and should be raised after each question and answer is reviewed. Each of you should have a Bear v. U.S. FAQ document that we'll review today. We do expect modifications will be made to it after today's town hall, and we appreciate your feedback. Today is not a debate to persuade your fellow Quapaw citizens. We'll not be voting today. Again, we will not be voting today. Debate and voting is reserved for September the 30th. Today is to ensure fact-based information is widely available. We do have one invited guest today, Mr. Eric Giles, sitting over here on this side of the room. Raise your hand, Eric. Thank you very much. Of Drummond Woodsum. He's part of the Quapaw Nation Legal Counsel. You may recall meeting Mr. Giles in our July 4th General Council meeting. The purpose of his attendance today is to advise all of us on any parliamentarian questions we need to prepare for in the 9:30 Special General Council meeting. So now we're going to go ahead and turn our attention to the FAQ document. There are 25 questions and answers that the business committee prepared. We've already identified one other area that we know we need to include. So again, your feedback is appreciated for anything else where we need to fill in. I'll just go ahead and start, and then we'll, kind of turn it over to other people on the business committee. So when was the lawsuit introduced? It was actually started in 2002 and was introduced as a breach of trust suit against the United States government. A long time ago, right? Over 20 years ago. Who was the lawsuit filed on behalf? And this is quoted from the Joint Agreement, Stipulation, and Recommendation for Proposed Fact and Conclusion of Law filed on January the 9th, 2020. And it stated, the Quapaw tribe of Oklahoma, the O-gah-pah, Thomas Charles Bear, and the enrolled members of the Quapaw tribe. That's what's listed on the court filing. The last one I'll take, and then I'll turn it over to Joey for the next one, but, what's the summarized history of the case? There's Appendix 1 is included in this document. We're not going to review that in detail, but it is provided as, again, it came from a court filing, those same findings of, findings of fact and conclusion of law back from January of 2020. And it's about 5 or 6 pages long. Doesn't seem like much of a summary, but for anybody that's gone through court filings, their idea of a summary and ours are probably two wildly different things. But there are relevant facts contained in that summary that we may reference as we go through the remainder of the FAQ. Joey, would you take question number 4, please?
Yes. So question 4 is, was this lawsuit settled? Yes, the lawsuit was settled January 2020 for $137,500,000 based on legal and equitable claims in the U.S. Court of Federal Claims.
For those of you who may be interested in understanding the legal definition of what a legal and or an equitable claim is, it is explained quite nicely in the Appendix 1. But there's specific circumstances to lead to that. I don't know if they call that a classification or a category, but there is a very specific definition contained in the appendix that helps define what that means. Linda, would you remember, actually this is pretty casual, so Linda, would you please take the next question, item number 5?
Yes. How much did the Quapaw Nation spend on the litigation, and did the nation pay for their own litigation costs? The Quapaw Nation spent $11,427,000 from 2003 to 2020 to 37 different vendors. The Quapaw Nation paid these combined litigation costs for Quapaw versus U.S., Good Eagle versus U.S., and Bear versus U.S. Of the total paid, 80% was paid to 2 primary law firms, $9,141,000. Of the total paid, 84% was paid by the end of 2018 in the amount of $9,642,000.
I know a number of questions have arisen either in business committee meetings or just one-off conversations. I've heard individuals assert that these lawsuits were paid on contingency. That's not the case. The Quapaw Nation, meaning all of its people, funded the litigation costs over the course of almost 20 years. So that's money that has already been expended. It has been spent. The money is out the door. The challenge is there's no reasonable way in going through the invoices, and Eric Boone's the one that has been maintaining this for a number of years. There's no way to distinguish, because all 3 of these cases were going through the Court of Federal Claims altogether. They went through simultaneously with each other. The labor expended by whoever, these 37 vendors, primarily the law firms, and many of the underlying claims were very similar. They're indistinguishable between each individual lawsuit. Okay. Questions about that? Sunny, would you take the next question, number 5?
Did the United States government admit fault? No, the U.S. government did not admit fault. However, they cannot be sued again for the same claims. These specified claims have been exhausted.
So what that really means is it never really went to a hearing trial. The settlement was reached before, and I think many of you may remember the initial, and it says it in some of the history in Appendix 1, it actually started in Miami. And that was a matter of, and shoot, I don't even remember what year it was, but it was very early on. But the reality of it is there was never a real hearing. At the time that they thought they were reaching really settlement agreements, settlement talks fell apart. At one point, everybody was told by the judge, go ahead, get ready. And what ended up happening was on the eve, literally the eve before the hearing was commenced, was scheduled to begin, there was an agreement in principle that was reached. And that was on September the 27th, 2019. Lloyd, would you take the next one? I think we're on question number 6.
Where can I find additional detailed court filings? Federal court uses a system called PACER. It requires a login and password to be established. There's a search engine so use the same name search of bear or the case. 1:13 CG-00051-TCW. There is a page charge.
Now, the page charge is pretty minimal, but I know a number of years ago when I started doing quite a bit of research on it, if I recall correctly, it was 10 cents a page. Some of the filings are actually free. Some of them, if they get to 30, 40, 50 pages, then they start assessing the per page charge. The reason we felt it was important to include this for those that want to conduct their own research, just wanted to provide where you can find these documents, at least those that have been, made available through the federal court system, this PACER system. Larry, would you take the next question?
Question number 7. Can we sue the U.S. government for something else? The answer is yes. There were certain items purposely left or removed from the lawsuit due to anticipated complexities, such as treaty water rights.
So at one point, water rights were included in the lawsuit or lawsuits, and that one was purposefully removed due to the necessity of getting the state of Oklahoma involved in order to, streamline, expedite, whatever the right word is, to minimize the number of parties at the negotiating table. It was decided at that time, I don't know by whom, but it was decided at that time to remove water rights. Those water rights have not been litigated. We're not asserting that they will be litigated. It's simply a matter of fact.
And Weena, does that include the state of Kansas for all those different towns along Spring River dumping into the river coming down to us?
I genuinely do not know. The fact that those tributaries were there long before there were state lines, I would assert that if that's within, this is my opinion, I would assert that anything within the reservation boundaries is within our, the original 1833 boundary lines.
All right, thank you.
What I really want to talk about is water rights in Arkansas, but that's a different issue for a different day. Sorry. Joey, would you take the next one, item number 8?
Yep. Has the Quapaw Nation received settlement funds? No, we have not. The settlement proceeds must be authorized and appropriated by the U.S. Congress.
So in the final language, and I'm trying to flip through and see it right now, the court makes it very clear in the findings of fact and conclusions of law that they're basically referring it to the hearing officer. The hearing officer in their final judgment basically said, we agree with this, and they were sending it to Congress at that point. When I say sending, all they did was refer it at that point. No legislation had been introduced at that time. But so the settlement was reached. We have not received any proceeds. Linda, do you want to take the next one, item number 11? Oh, yep, sorry. Flip Too fast.
Who will be paid settlement funds? The court filings available publicly do not specify a distribution method or to whom they should be distributed. The current Quapaw Nation Business Committee has consistently stated that all enrolled Quapaw members as of 9/27/2019 should receive the settlement proceeds fully and equally, still living at the time of distribution. Please see attached Resolution 082121-A and 091821-A.
In your packet, back behind the FAQ questions and answers in Appendix 1, both of the resolutions have been attached, okay? So there are, I don't want to fast forward, but the fact is these two resolutions are a direct result of a Quapaw tribal member-led petition effort, the goal of which was to compel the business committee to be very specific about who the settlement proceeds should be distributed. Why are there two of them? Well, the reason is that the petition got certified, if I recall the date correctly, the petition got certified in late August. And it looked pretty likely that it was going to get certified, meaning the appropriate number of signatures had been obtained of registered voters. And maybe others remember a little bit more about what was going on at the time. But the business committee at that time decided to go ahead and pass their own resolution. According to the election ordinance of 2004, when there is a petition-led effort with the required number of signatures that gets certified by the enrollment in the election committee, the business committee has two choices. They can either pass the exact version of the petition, no changes whatsoever, or they have to send it to the Quapaw people for a vote. Those were their only two options. The August version of the resolution has some very slight differences in language that in my mind are kind of be more non-substantive, meaning they don't change the intent. But the BC also was compelled to pass the version of the resolution in September of 2021. Had they not done so, it would have gone for a vote. They would have had to send it to a vote at that time. Okay, so both of those versions are contained in your packet. Sunny, would you take question number 10, please?
Why does it include all enrolled Quapaw members as of 9/27/2019? February 14, 2014, the lawsuit was amended to add all enrolled members of the Quapaw Nation. The amendment complaint stated 9A, attached and in Exhibit A is a list of 3,580 individuals, each of whom is presently an enrolled adult member of the Quapaw Nation or Quapaw tribe of Oklahoma, and is also a lineage descendant of one or more persons identified on the original list of enrolled Quapaw tribal members certified by the Secretary of the Interior Department on February 8, 1890. The subsequently reinserted by the Secretary as the judgment roll listing all members of the Quapaw tribe of April 1961. Each individual listed in Exhibit A is, by reason of his or his lineage, heritage of all of the all or a portion of one or more original allotments of the Quapaw land made to the made to the members of the Quapaw tribe, ratified by the Quapaw Allotment Act of 1895. Claimants are informed and believed and thereon allege that each individual named in Exhibit A thus have a claim under one or more of the cause of action in a congressional referendum litigation. Claimants reserve the right to seek leave to add additional claimants, a new information being available. Finally, claimants may seek to amend the complaint to account for tribal members who died or who attend majority age during the pending of this case.
So Exhibit A in that court filing that you can find on the PACER system literally lists the individual names of 3,580 enrolled tribal members. Now, we know that list was not perfectly accurate even at that time. And we know it's not perfectly accurate as of today. But I would assert, again, this is my opinion. This is not necessarily the court filing, what it states, because Sonny just read what the amended complaint stated. The intent was to include all enrolled members of the tribe. That was the intent, and the court accepted that on February the 14th, 2014.
On the next page, on page 3, I didn't get that last part. Significant of this date, 9/27/2019. It was the date settlement was agreed to in principle.
That date's not a guess. It's actually in the court filings. So some of the, and I'll be honest with you, some of the filings that I've seen actually reference September the 28th. Upon looking at the calendar, September the 28th was actually a Saturday. You know, I don't know if the right date is on a Friday or a Saturday, but the reality of it is most of the court filings reference September the 27th, 2019 as the date in which the settlement agreement was reached in principle. That's the reason for that date. Lloyd, would you take the next one?
In reference to what you just said, I received a call late the evening of 9/27/2019 from Chairman Berry, and he signified that that was the final date.
Thank you. I love it that we have firsthand corroboration.
Question 11, how do we get Congress to authorize and appropriate the settlement funds? Authorization and appropriation bills must be introduced and passed in the U.S. House of Representatives, U.S. Senate, and signed by the President of the United States.
Larry, would you take the next one?
Yes. Question 12. What was wrong with the original bill, H.R. 4715, introduced 7/27/2021? The language was vague. They could have led to misinterpretation by the Department of the Interior when it comes time for writing checks. That's why updating the bill language is so important, so that each enrolled tribal member as of 9/27/2019 receives an equal share of the settlement funds. In addition, H.R. 4715 was never passed by the Natural Resource Committee, so was never introduced to the floor for vote. That bill was never passed.
So when the bill was originally introduced, and it's easy for me to remember that date because it's actually my mom's birthday. I remember when I got word. Of course, I was not elected at that time. I was a tribal member, just trying to pay attention and trying to understand what was going on. So it was in the middle of my mom's birthday party, and I remembered reading the language that was used in the bill, and just being a little bit dismayed, to be honest with you. Because I'm like saying to myself, what does this mean? What could this mean? Does this confirm what we had been told previously or not? And so that's when the real digging and the research began. The bill was introduced on that date in 2021, and then you can see on the U.S. congressional records that it was immediately referred to the House Resources Committee and then the appropriate subcommittee. Can't remember the full name, it's a lot of words. There was also a hearing on that H.R. 4715 on March the 31st, 2022, And at that time, Chairman Byrd testified, did a great job in providing his testimony in that subcommittee hearing. The bill never went anywhere beyond that point. It stayed in the subcommittee. When Congress, and I've kind of had to learn this the hard way, you know, my idea of my learning about bills is from Schoolhouse Rock in the early 70s. Remember? It was actually pretty fun. That's kind of the extent of my knowledge of it. That bill never got out of subcommittee, and when Congress, you know, was called out of session, any bills that haven't made it all the way to a vote, they just basically wither. They wither. So that's when we're going to get to the next piece, but it was that bill never went beyond the subcommittee, and that's where it stayed. Joey, can you take the next one?
Yep. Question 13 is, how many enrolled members are there as of 9/27/2019, and how much would each receive? There were 5,319 enrolled members as of September 27, 2019. Unfortunately, 115 have passed away since that time. If the settlement proceeds are distributed fully and equally to those still living, each would receive $26,422. For reference purposes, there are 5,953 enrolled members as of right now.
So we just wanted to get the numbers out there, and I think during Steve's update earlier in the business committee meeting, there's been one additional enrolled member since I got these updates. So it's actually 5,954 enrolled members right now. So it doesn't really change the math a whole lot, but just to give you guys a sense of the scale of what we're talking about. You know, I can only state from my own perspective, this is in my opinion now, not on a legal filing. That's an incredible amount of money to us as individuals. Okay. Linda, would you take question 14, please?
Absolutely. Didn't we already update the bill language? No. The Quapaw Business Committee passed Resolution 041523-B, which is attached. It spelled out the full and equal distribution of the settlement funds to all enrolled Quapaws as of 9/27/2019, still living at the time of distribution, and removed the reference to, end quote, landowners. The recommended bill language updates were submitted to our targeted Oklahoma delegate sponsors in both the U.S. House and Senate. However, again, the updated bill has not been introduced.
About 2 years ago, there was some discussion around, you know, HR 4715 when it was originally introduced. There were conversations at that time with the staff of the introducing congressman. If you recall, that one was actually introduced by, at that point, House of Representatives member Mark Wayne Mullen, co-sponsorship by Tom Cole. We were told at that time that additional specificity in the bill language was inappropriate and uncalled for. You know, I don't really believe anything that anybody tells me. I want to know what I can prove, right? So a number of us started making contact with House Member Mullen's staff to verify the validity of those statements. And we're told directly and in writing by Congressman Mullen's office that the additional specificity would actually be helpful. At that time, there were a number of mentions, phone calls, letters written that we need to modify the bill language. And that's the reason that ultimately the Business Committee came together and passed the resolution on April the 15th. Like Linda said, a copy is attached of both the resolution as well as the updated bill language. Sonny, would you take question 15?
Why has the bill not been introduced into the current Congress? The Oklahoma delegation was contacted and lobbied by representatives of the Plaintiff Group 2, disagreeing with the updated bill language. The Oklahoma delegate had communicated that they will not introduce a bill for the Bear settlement until Plaintiff Group 1 and Plaintiff Group 2 can come to a common goal?
So many of you may be aware from recent business committee meetings that Quapaw Nation Business Committee has been to Washington and visited with a variety of House members as well as Senate members 3 times since the beginning of this calendar year. On the third visit, and we kind of thought, by that point, we had the updated bill language. We had good sponsorship on both the House side as well as the Senate side. And not just with the Oklahoma delegates. We'd spent a significant amount of time with delegates from the state of Arkansas, Kansas, Missouri, Colorado, and Montana. The reasons for those other states, Arkansas is pretty obvious. We also have incredible economic interests in Missouri and Kansas, but we also have significant volumes of tribal members that live in some of these other states, and they were receptive to our meetings. We thought we were on the edge of getting the updated bill language introduced based on the resolution that the Business Committee had passed on April the 15th, only to find out that there were other forces working against us. That was obviously quite disappointing, and I think we've talked about that in previous Business Committee meetings. And then subsequent to that, we were also told, based on some expected meetings to occur between our House delegate as well as our Senate delegate, that nothing would be introduced until these groups come together. And we'll talk a little bit about who those two groups really are. But I would just, this is a side note, and I'm trying to be as fair-minded as possible, as difficult as it is at times. They're politicians. The way they get to stay in office is they get elected. And if there's diversity, controversy, if there's a reason for them to do nothing, they will. That's kind of their incentive. So we have to be mindful of their motivations as we speak, we interact, and we hopefully persuade them to help us. So just a little side note. So if you don't mind, we'll get to that. Yeah, great question, though. Excellent question.
Yes, ma'am.
16, I got it. Who is plaintiff group 1 and who is their representative? Plaintiff group 1 are all enrolled tribal members for the court filing of 2014. They had no legal representation since 2020. On September 12, 2023, RSM and Hobbs Strauss were engaged to perform an independent and comprehensive allocation and distribution review of both the Bear and Good Eagle settlements.
So many of you may remember, especially if you were one of the plaintiffs in Good Eagle v.U.S., we actually received letters from Marzullo Law saying, thank you, we've been thrilled to represent the Quapaw Nation. We're done, okay? So that kind of concluded, because if you think about it this way, the settlement had already been reached. The documents had already been completed. The reference to the hearing officer was over. There really wasn't a whole lot for them to do at the time. Now we find ourselves in a very different situation in trying to get the legislation introduced. Yes, do we have lobbyists? Yes, we have general legal counsel. Eric Giles is here today to help us. So we do have legal counsel. But when it comes to moving forward the Bear legislation, I think that's where we have, I don't know, kind of slowed ourselves down in certain ways. But we're trying to kickstart it again. We just signed the resolution to engage RSM and Hobbs Strauss, and we look forward to their analysis and reporting back to the Quapaw people.
Question number 17. Who is plaintiff group 2 and who is their representative? Plaintiff Group 2 is comprised of approximately 53 enrolled tribal members who sought their own legal counsel early in 2019. That was their right to do so. They are represented by their own legal counsel.
So earlier in the FAQ document, we talked about the cost of litigation, that 11.4 million that was spent over time. That's the reason we wanted to include in there, well, how much did the Quapaw Nation spend up to the time this other group came into existence? Well, according to our records, 9.6 million was paid for litigation of all three of those lawsuits by the time Plaintiff Group 2 sought their own legal representation and achieved that. Okay. So I just wanted to draw that to everyone's attention. Joey, can you take question 18, please?
Why does Plaintiff Group 2 expect the full settlement proceeds when they were already paid through Good Eagle versus the U.S.? We do not know, since the Quapaw Nation Business Committee does not speak for Plaintiff Group 2.
Linda, could you take question 19, please?
Yes. I have heard rumors Plaintiff Group 2 has tried to recruit tribal members beyond the 53 to agree with them and only pay the landowners. Is that true? If that is true, then why has the nation not taken legal action against them? We have heard those rumors as well. We would ask that you consider the following. If your family members were enrolled as of the date in 2019 and there are 10 in your family, then your collective family would receive $264,220. Is that more than you were promised? We are not aware of any direct recruiting done by Plaintiff Group 2's legal representative. Our understanding is the rumored recruiting has been done through intermediaries.
Does that make sense to you guys? Just wanted to make sure, if you start thinking about the size of even immediate families, let's just do the math and think about what does that really mean to my family. I was recently contacted by a tribal member who wanted to understand the status of this lawsuit. They were interested in understanding what the amounts were, because they're 5-person family member and they're all 5 enrolled Quapaw members, 3 generations renting. That's fine. A lot of us rent. They would think that they may actually, if this comes through for the first time in those 3 generations, they might actually have the ability to buy their own home. They might only have the ability to buy their own home. That's the kind of impact we're talking about in terms of individual tribal members as well as their families. That's what this could do for us. Sonny, would you take the next one, please?
In the 9/30/2023 Special General Council 3, we are expecting to vote on the agreed upon terms for Plaintiff Group 1 and Plaintiff Group 2. No, the negotiation will take place after the 9/30/2023 Special General Council, once the will of the Quapaw people is determined by vote.
Does that make sense? So the Oklahoma delegates have told us they won't introduce any legislation into Congress unless the 2 groups can come together for a common purpose. So we're not trying to come to that common purpose in Special General Council. Well, we're really trying to understand, and we're going to get to that in this next question. It's a good question.
We have a
Question
in the back.
21.
Catherine.
No, 84% of that total, the entire 11.4 million has been paid. 84% of that was expended in up through the end of 2018. It's all paid. Yes. No. The Quapaw Nation members, those are your assets. That has all been paid to the 37 vendors and primarily lawyers. Does that help? That was completely paid.
Question 21. What is the purpose of the 9/30/23 Special General Council? 3. It is to determine the will of the Quapaw people, the most powerful voice of the Quapaw Nation. That is the voice that needs to be represented to U.S. Congress.
One of the things that was so disappointing in this last Washington visit was that the individuals that you have elected to speak and act on behalf of the Quapaw Nation are now in the unfortunate set of circumstances that we've got to negotiate with some other party. In order for us to understand your intent, your wishes, your desires, that's when we vote. That's what we do. That's the purpose of September the 30th. We want to understand what it is that you want done. And then we'll get to what it is the BC is compelled to do as a result.
I got a question.
So the question for those on Zoom, in case, and Shani, let me know if I do your question justice or not, but the critical part of the question is, well, why does it matter what this other group says? If this is what the Quapaw Nation decides is done, why do we even have to negotiate with them? Congress has something that we can't do ourselves, and that's compel the federal government to pay us the $137.5 million. So that means we have to kind of play their games, if you will. We've got to come to some resolution in order to get these congressional members to act upon, what we need. And what we need them to do is to introduce a bill that ensures fair and equitable payment to all enrolled tribal members. Correct. The initial filings for different representation actually occurred in what I can find, and then maybe some of these firms that we've engaged to do additional research. The first filing I saw was February of 2019. And that's the reason I kind of fixated on, well, how much did we spend by the end of 2018, right? That's almost 10 million. But yeah, and there were reasons, and I'm sure there were very compelling reasons to obtain their own legal counsel, which they had the right to do so. But that was based on, at that point, 17 years of litigation paid for by all of us, the Quapaw Nation.
On 22.
We're on 22. Will tribal members have an opportunity to speak and debate the best allocation of the bear settlement proceeds during the Special General Council number 3? Yes, the discussion and debate are the most critical thing we can accomplish for Special General Council 3, along with calling the vote.
Joey, could you take the next one?
Can a motion be made to send the vote to the election committee for balloted election? Yes, it can. A motion can be made to send the vote to a balloted election as long as the motion is seconded, discussed, and a majority vote to accomplish that. Known as a referendum vote, correct?
I think this is where we need to pause. And there are a couple of different, I don't know, they're not called options, but we have our governing resolution in section 14 is very specific about not only what we do, but how we go about it in terms of taking a vote. Okay. But we also have an election ordinance that was passed in 2004. And so the question becomes, if someone makes a motion, and that's an if someone makes a motion to say, you know what, we love it that we're all here in a room together, but what about my aunt, my uncle, my grandparent unable to travel and they couldn't be here in this room? Who's fighting for them? How do they make sure that their voice counts as well? And so, a number of people have asked, could we send it to a balloted election? And the answer to that is yes, based on what Joey just explained. But the second question is, well, does it go to all eligible voters? Okay, that means 18 and above plus Quapaw blood voters, big number of people, according to section 14 of the governing resolution. Or does it go to registered voters? We heard Steve's numbers a little bit earlier today. It's a little over 1,600 people. So that's the question before us to some extent. And our goal is to ensure that we've got good legal advice that helps us dissect those questions and come up with the best answer policy.
Madam Chair, it's my opinion, a referendum vote will go to specifically what Section 14 says, even though it references amendments to the resolution. It says eligible voters. All general councils, this nation has recognized registered voters and non-registered voters as eligible to vote in general council. My opinion only. You may agree with me or disagree, but I believe that referendum vote, if it happens, should go to all individuals 18 years of age and over, based upon the prior way that the general council is conducted, where everybody votes.
We just want to make sure that by the time we get to September the 30th and have that special general council, that we have the I don't know, I keep using the word options, but I know it's not right because it's not like it's an option. It's a definition of who can really vote, right? Because the definitions are wildly different between eligible voters versus registered voters.
How they vote.
And how they vote, exactly. So those are the kinds of guidance and advice that we will be seeking and defining. And as that information, we're not going to wait till September 30th. If some of that information becomes available in the meantime, we will absolutely get things like this FAQ document updated appropriately on both the Quapaw Post social media as well as the tribal website. It does take time, but once somebody puts in, there's a form out on the website to become a registered voter. It's pretty straightforward. The election committee meets every single week. Is Frank in the room? I'm not going to, the election committee they're very, very judicious about the way they follow their policies and procedures to certify that someone really is eligible to be a registered voter, and then to do so. So, but they meet all the time. So,
As a former person on the election committee and former chair, it is a quick turnaround process. I can't give you a definitive, 3 days, 5 days, but I can just straightforward tell you it is a very quick turnaround process. There is due diligence to make it a quick turnaround process.
at the same time, whatever it is, the outcome is, whether it goes to all eligible, it's just the people in the room that day, which are all eligible voters, or something more broad that includes the ability to absentee vote. I think that it's imperative that we ensure our procedures are followed, because the last thing we would want to have happen is to go through this process only to find out, oops, we got to do a do-over. You know, that procedurally there was a violation, and then it causes more damage than good.
Madam Chair, there's also an additional complication is the fact that the nation allows individuals that are Quapaw by blood, not enrolled, to register to vote. So the answer, how do you handle that? You can see that's complicated, who gets to vote.
Absolutely. Absolutely. But, and it's incumbent upon us to make Eric Giles.
He's taking lots of notes.
Oh, that's me. Yes. Question 24, can a motion be made with different language? For example, the settlement proceeds should only go to elders, or further specify how the proceeds for minors will be held in trust until reaching the age of 18 or 21, or based on proportionate share of current land ownership, or remove the phrase, in quote, still living at the time of distribution, or held by the tribe to fund tribal member services, or establish an investment fund to fund tribal member services through interest and dividends earned, etc. Yes, a motion can be made for different language as long as the motion is seconded, discussed, and a majority vote is reached.
So although there have been 2 different resolutions passed by the Quapaw Nation Business Committee calling for the full and equal distribution to all enrolled tribal members as of that date, still living at the time of distribution, remember, General Counsel, that's you guys. And so alternatives, other ideas can be brought forward, and I'm kind of hoping they do, because that, again, it helps solidify what the true will of the Quapaw people really is. And that's important. And I'll not argue, because remember I said we're not going to debate. I'll not argue any one or multiple of these, but you can clearly see there are alternatives. You know, our goal was to get the money out to everybody just as quickly as it got appropriated and became available, whereas others may have very strong ideas and compelling arguments to do something different. That's okay. It's your meeting.
Whatever motion is passed by the majority vote, is the Quapaw Nation Business Committee compelled to then act on the vote? Yes, the Quapaw Nation Business Committee serving the Quapaw people, the Quapaw Indian Council, aka General Council, is the supreme body of that government of the Quapaw Nation. Therefore, it is the duty of the Quapaw Nation Business Committee to act based on the will of the Quapaw Indian Council.
So whatever we end up deciding on September the 30th, in terms of the intended outcome, it is our obligation to fulfill that. Just like when you guys voted on the 16 amendments to the governing resolution, we came back to you at the next business committee meeting and said, and you had every right to do so, say, what are you doing about it? What have you done? And that's why we were compelled to act at that point, because, you know, it's not what we decide, it's what you guys decide is important, and that's what we will do. So those were all of the prepared questions, but there were a couple of other things that came up that in the last few days. Linda, do you want to share with folks? Because it really speaks to the notion of, and we didn't include it in the FAQ, and I think that was a missed opportunity, and we'll address that tomorrow. And that is, what were we told as Quapaw tribal members at various points in the past? What were we told throughout the history of that bear case? And
yes. Okay, so what I have before me in my hand is an annual report of the General Council of the Quapaw Tribe of Oklahoma, June 1, 2016 to May 31st, 2017, and it's from Connors and Winters, and at that time, that was our attorneys and counselors at law. The annual report prepared by Connors and Winters LLP provides the Quapaw Tribal Business Committee with a summary of the legal affairs of the tribe during the past year. In view of the importance of maintaining the attorney-client privilege, some information about the tribe's legal matters must remain confidential and cannot be disclosed in public documents. However, this report identifies the major legal initiatives and litigation in which the tribe has been involved in the last year, and thereby provides an overview of the activities of the General Counsel during that period of time. So in summary, the significant legal activities in last year have included assistance with ongoing settlement discussions in the tribal members' breach of trust litigation, legal support for ongoing economic development and diversification initiatives, support for the operations of tribal government and enterprises. In reference to the tribal members' breach of trust litigation, the most significant legal activity of the Quapaw tribe over the last year, the tribal member breach of trust cases, Good Eagle versus United States and Bear versus United States, have continued to move toward a conclusion. The parties have been engaged in settlement discussions since the trial began last fall, and the parties are continuing to work toward reaching a final resolution. Trial in the cases which are pending before the United States Court of Federal Claims began on September 21st, 2016. The presiding judge, the Honorable Thomas C. Wheeler, conducted the first 2 days of the trial in the old federal courtroom in Miami, Oklahoma, in order to accommodate tribal elders who were designated as witnesses. Prior to the start of the trial, Judge Wheeler, accompanied by counsel, toured the Quapaw Reservation, including areas of the former mining district. The trial was scheduled to resume in Washington, D.C. on October 11th. However, the night before, the parties reached a tentative agreement in principle regarding the monetary component of a proposed settlement of all the claims in the cases. Based upon that agreement in principle, the parties jointly requested that the court delay the trial to permit them to have adequate time to negotiate the terms of a final settlement. Since last October, the settlement discussions have proceeded continuously. The parties have met periodically and have also continued their discussions by conference telephone calls. As a status conference in May, the parties reported to the court that they were continuing to make progress in the discussions. As the parties have advised the court, the negotiations have taken a significant amount of time because of the number and the complexity of the issues involved. The next status conference is scheduled in July. The Good Eagle and Bear cases are the result of more than a decade of planning and preparation by tribal leadership. The claims of the tribal members were developed in large part through a project known as the Quapaw, as the, and in quotes, Quapaw analysis, which was the result of accounting litigation filed by the tribe in 2002. The Court of Claims litigation was initiated in 2011. Many tribal members elected to opt out of the nationwide COBEL settlement to pursue their claims separately in the Quapaw cases. The Bear case, which involves claims for all tribal members for which the statute of limitations has run, was made possible through special legislation passed for the tribe by the United States House of Representatives in late 2012. Economic development and related initiatives. Tribal Council provides ongoing support for many initiatives and projects of the tribe, including efforts to expand and diversify the enterprises that generate revenues to fund government services. In the last year, Council has assisted with key matters including financing for tribal enterprises, real estate acquisitions needed to provide an adequate land base for the tribe's expanding enterprises, assistance with contracting and other matters to support the operations of tribal enterprises, including those engaged in environmental remediation, construction, and agriculture, gaming business matters, including support for negotiations of major new gaming contracts, environmental matters, and regulatory and tax matters. This letter is dated May 31st, 2017.
Can you read that one quote again, Linda, where it's all enrolled tribal members?
Yes, Madam Chair. The Bear case, which involves claims for all tribal members for which the statute of limitations has run, was made possible through special legislation passed for the tribe by the United States House of Representatives in late 2012.
So that's typically when you hear people talk about HR 5862 that Tom Cole sponsored. And it really was pivotal to our case actually going through the court successfully. Now, the one thing that the letter says it's for all, that's good, but it doesn't say equal. In 2018, at General Counsel, there was a prolonged discussion around, well, it looks like we're getting pretty close to settlement. I'm paraphrasing, I apologize, but, we're getting pretty close to settlement. It's taken a little bit longer than we expected. The good news is, everybody's going to get paid $15,000. I think it was $5,000 over the course of 3 years. If you do the math, it does not total $137.5 million. It totaled about 40% of that. It's unclear to us what the intended purpose of the remaining settlement was, but at the time it was discussed along the lines, well, it might be difficult to get through Congress to appropriate such a large dollar volume, large dollar amount in a single congressional session. Regardless of those statements, but the point is, even in 2018, the statements were made that everybody was going to get paid the same amount of money. And I think that's important because it sets the stage, whether that was conjecture or on the bedrock of legal evidence and fact. I don't really know, but that's the reason we have hired both RSM as well as Hobbs Strauss to dig into not only the public court documents, but others that may be sealed or others, other analyses that supported that, like the Quapaw analysis, that could glean meaning and help to us. And I know they're trying to expedite their review. Those firms are actually going to be here in Quapaw next Tuesday. We'll be doing really a half day of kickoff sessions. A number of documents have already been turned over to them, and we welcome their help, their analysis, and they will be reporting back to not just the business committee, but to the Quapaw people. They will be present that day on September the 30th, and I do expect that if there's new information that comes to light, then we'll have them share that at that time. Those were all of the prepared questions that we had. We know we're missing, what have we been told, by tribal leadership or general legal counsel over time. So we'll be adding that. I do want to make sure we've got ample opportunity for questions. Ms. Grace, could somebody provide Grace a microphone, please? Might there be one available?
Thank you. My name is Grace Goodeagle. That name has come up quite a few times. I did want to mention a couple of things to address what has been mentioned so far. One was this all started under the administration of John Berry. And so with the first suit, with the plaintiff group 2, it was mentioned that there were those who sought their own legal counsel. And we did that, some of us. We paid for that legal counsel. Quapaw Nation did not. So when you're looking at those legal costs that were involved, as far as the group 2, we hired our own attorney and we paid them. So that needs to be clarified there. Also, rumors. Group 2 has tried to recruit tribal members beyond, to agree with them and only pay the landowners. Is that true? No. We did not say that. One of our concerns was, though, that we had heard that there were some people who were saying under the Bear litigation that the landowners would be excluded. They would not receive anything from the Bear case. And it's been stated so far, all Quapaw members would be eligible for this. I'm Quapaw. I was part of that first lawsuit as far as the landowner. So again, I just wanted to address the group to let you know. Group 2, I'm Grace Good Eagle, and I was part of that. But as far as the bear settlement, it was the sort of thing, again, we had heard that we were going to be excluded. We were going to be taken out. And when you can say all Quapaw, I thought, how can they do that? So I'm glad for clarification. I'm very glad for information. I received some information because even plaintiffs in that pursuit, we didn't get all the information either. From John Barry and from the legal counsel. So we're learning some things too. But I did want to clarify those points. This was all started under John Barry's administration. And yes, there was the group 2. We paid for our own counsel. And as far as distribution, that indeed is up to what can be worked out amicably. So that's all I have to say. I'm gonna go.
Thank you so much, Grace. Most appreciated. Other questions from either the audience or even from Zoom? Here is a question.
My question to Grace is, are you representing the 53 people that you're not trying to change that as major landholders, that you just want to be included in the whole group? And the 53 agree. No, I mean, are you speaking for the whole group? And that's what's been discussed.
I'm sorry, I can't really hear the question. My apologies.
I think I have a similar question to you. For you, it was my understanding that it was all Quapaw members that were on the roll as of September 27th, 2019. Is that correct? So it was always for all. But now we have an extra group that wants it just for the 53 people? Okay, not for all. Okay. And then as far as the legal fees, I think that we were just earlier, whenever I was clarifying that we had paid 11 million for the legal fees, that was up to 2018, I think, or whatever it was, before the 53 decided to pursue. Right. So, but all of the progress that we had made as a tribe was paid up to that point was paid for by the tribe. So the 53 people are benefiting from that, is what I was saying, not. So that's what I was saying. Because we had made a ton of progress for years, right? It's been going for years up to that point, and
Right,
that was
since
paid.
2002 was when it
So-
started.
So that's a lot of money.
Any questions from Zoom?
All right, first we have we'll do Brandon's first. Start at the bottom. What is being done to reach an agreement between groups 1 and 2? And what is that group 2 wanting in order to reach an agreement?
We're still trying. Well, okay. I think the first question was, what is being done between groups 1 and 2? Is that correct? There have been some initial discussions, but that's really it. Nothing in terms of terms, timing, anything of that nature. It's pretty open-ended right now. What our goal was, we wanted to assess the will of the Quapaw people before proceeding in any other way. Because for us to front run and assume we know would probably be irresponsible. What was the second question again? I'm sorry.
The second question Brandon Harkins had was, what is Group 2 wanting in order to reach an agreement?
Thus far,
I am speaking, this is Grace Good Eagle, but I am speaking from what I know is the fact that, yes, we were aware of the Congress people were wanting Group 1 and Group 2 to get together. The settlement monies are already there. The discussion is about distribution. And so it was suggested to Group 2, how can you get in touch with Group 1? And so I know a letter was sent. And so it's been kind of going back and forth, but it's a matter of getting together. Right now, we've got legal counsel going on with it as well. But I do know that a letter correspondence has been initiated from Group 2.
that is correct.
All right. Kelly Flanagan, correct me in chat if I am misinterpreting this wrong, but it looks like she is wanting about what point in the timeline Group 2 became involved. She's wanting to know about what point in time did Group 2 form in this whole entire process. Oh, she's wondering about what time you guys started forming.
Well, we had the original plaintiffs in that first suit, in the Good Eagle suit. So there were a number of families there involved with that suit. And so I guess Group 2 would be referring to those plaintiffs in the Good Eagle suit. And then, but we were also involved with the Bear case. Originally, there were 3 cases when they started out. Good Eagle, the landowners, Bear, and the Quapaw tribe. Then that's when John said, let's combine a couple of the cases. So the Quapaw tribe case got included with the Bear case. So then we had 2 cases. And so it was thought in the beginning, okay, let's have the Good Eagle name again along with the Bear case. So that's, I guess, the Good Eagle, the plaintiffs in the Good Eagle suit then would be, I guess, Group 2.
So I can say that based on the court filings, and this is exclusively what I'm basing this statement on, is that all 3 of those cases, Quapaw v. U.S., Good Eagle v. U.S., and Bear v. U.S., obviously they all traveled through the court at the same time. They were all settled at the same time. If you look at the documents, all 3 of those specific suits are listed. There are money damages for a combination of, and this would only be applicable to plaintiff group 1, that settlement agreement combined the damages for, or at least the settlement proceeds for both Quapaw as well as Good Eagle. And then Bear was stated as a standalone. Attached to that filing, the documents are basically, there's one for Group 1, and there's other documents for Group 2. Group 2 exists on all of those cases except for Quapaw. It's clearly relevant for both Good Eagle as well as Bear in looking at the exhibits associated with those court filings, and that's what I'm basing that on. As also in terms of the timing, I can also say that the first filings that I've been able to find where people were basically saying, you know what, I don't want the Quapaw Nation attorneys to represent me anymore. I want a different attorney. The first filing I saw out there was February of 2019. And by probably the middle of February, there were 16 individuals named. And then, you know, how that group grew a little bit beyond those few to 53. I can't find any of those filings, but the first instance I can see where individual Quapaws sought their own legal counsel. In order to do that, you have to file with the court, say, I don't want that one to represent me. I want this other one to represent me. And that was in February of 2019. Other questions from Zoom?
Yes, I believe Jim Adams' question was just answered by Grace. He was asking who Group 2 consists of, as in the members of it. But I believe you just answered that in the previous question, Grace. I also have a question from someone who is asking anonymously. Do we want to take that question?
No. Declined.
Jamila is asking if we have an official list of which specific members are included as of the 2019 date.
I'm not aware of a list other than our enrollment records. Do you recall a little bit earlier when we went through the FAQ? Joey, I think, addressed that particular question where we know how many people are enrolled today. We know how many people were enrolled as of 9/27/2019. And of that count, we know that 15 have unfortunately, 115 have passed away since that time. So the data is available. We are not, for privacy purposes, we are not in a position, and I don't know if we ever will be, to state that full list of individual names other than by direct contact with those individuals.
Either that, or I'm not sure about the confidentiality of personal information, but they could also get a hold of the enrollment department and then ask how many and who's been deceased since that time, and just subtract the 115 from the grand total of people since September 27th, 2019.
Good point. Is that the concern, Mikhail, that someone perhaps wants to know if they themselves or a family member was enrolled by that date? If that's the case, then Joey's advice is spot on.
I mean, just trying to think of it from the other way.
But just update us in chat, Jamila, if that is what you were trying to get for there. I have another question from Brandon Harkins. He is a question for Grace, if possible, here. Okay. He's wondering if the issue was that Group 2 was concerned they would not be paid in the lawsuit. It seems abundantly clear that they will be included. So why can't this not be quickly sorted out in order to benefit the tribe as a whole?
When the Steve Ward was with Connors and Winters, would you repeat your question, please?
the issue was that, oh, he's wondering if the issue was that Group 2 was concerned that they would not be paid in the lawsuit, referencing Bear. It seems abundantly clear that they will be included. So why can this not be quickly sorted out in order to benefit the tribe as a whole?
Well, I think again, as I started to say, was the Steve Ward was telling us that to have the bear suit, that our names would be included with that, so that perhaps the Good Eagle name would carry over or would be helpful to getting the bear suit through. But he said we would benefit as being part of that suit. Because again, it was for all Quapaw. But then there, as I had mentioned earlier, there was a concern that we had heard some people were saying, well, the landowner shouldn't be part of the bear suit proceeds. And that concerned us. Why were we being taken out? I mean, the suit is there. The bear name, T.C. Bear, Thomas Bear, and in the others. So that was a concern until it was clarified that no, that's not the case.
Right, it's all.
When we're saying,
Matter of fact, even back in that filing in 2014, where the 3,580 were added, it's very clear in that amended complaint that it includes the original individuals, and there were 9, okay, including these some of the names that you just referenced, included those original 9 plus the additional 3,580, and those names actually appear on those court filings.
so again, that was again why we had heard this, and so we wanted clarification on that. And I think I better leave it at that.
And Brenda has a question up here as well.
So we just had a question for Grace asking if she believed that Bear should be divided equally between all the members.
That is my position, again, because we wanted some clarification about it. But as I've been hearing recently about feelings among I personally, and of course, in a sense, I'm representing the Good Eagle family, I'm perfectly thinking, yes, perhaps equally among all Quapaw. That, again, would be my position.
Brenda, I'm sorry, there was another question up here.
Hi, I'm Brenda Murray. The 53 that started in that panel, or the second panel or group, yeah. So many of them have passed away that started that. So how many are left in it?
I don't genuinely know.
And TC. Dina Flossie, TC.
And I think there's another question on the back row.
Go ahead.
My name's Kagi Superlaw. I think getting confused here. The problem between the 53 and the rest of the nation is not area. All right, can you hear me now?
Much better.
The problem is, the difference is the 53 Bear, they want to participate in the suit and the settlement, but not equally. Now, Grace says she wants it equally. Well, I applaud that. But I think the rest of your group is not wanting that. They want a settlement that, this is, I haven't done the math on it, but those that have said that they will end up with over $100 million, and the rest of you, now that's as a group, and the rest of us would get about $250. And from some point of view, that sounds equal, but I don't know to who. It doesn't sound equal to me. But my problem is that I think we need to have a clear understanding of this difference in what, how are you going to, you're never going to get these two groups to agree. There's always going to be a difference, and the only thing that we can do as a nation is to vote as a nation that we distribute it equally. Now, the problem with going to a general council, and I've been to lots of them, it's like I don't know, Longfellow or somebody said, you know, you let slip the dogs of war, you don't know who they're going to bite. The way that's a little confusing as this is with everybody. Someone get up and really emotional, make a big talk at the general council. People may want to start picking apart everything and even make it more complicated and more unsure as to what's going to happen. People can get up there and they may even attorneys say they're going to be doing a lot of talking. They can say about whatever they want to say. And now that you have that in your mind and vote one way, you don't get a chance to correct it. They could vote any way and change everything unless we go in there, everybody, clear understanding of what each side's wanting to do, and just have your ducks in a row. But I'll tell you right now, they're not in a row. Anything can happen right now. And we only have 2 weeks, approximately. I couldn't tell you what's going to happen now. I've heard here. Nobody else could. The only thing that I know that anyone can guarantee is that the 53 people, if they get their way, they're going to get the big lion's share of the money, and their attorney's going to get 40% of that. Those are the only guarantees I think that you're going to see.
So this could still be a win-win situation. If we can get group 1 and group 2 together to talk over these things, and perhaps group 2 then can get together on what their position would be, because that was the idea. Get the two groups together, talk to one another, work it out type of thing. And we're all Quapaw. We should agree, or as best we can, but it's a sort of thing just to throw out a couple of biggies, blood quantum. There are a couple of people on the roll who shouldn't be on the roll. So there were some other issues that could be involved with this. But as far as the bear settlement, it's the sort of thing, again, if we can get group 1 and group 2 together, then united we could go to Congress and say, yes, this is what we want. So it could be a win-win.
Yeah, September the 30th in the Special General Council will not be a negotiation between those two groups, but what we're hoping to achieve with that vote is understanding at least what Group 1, and more tribal members want without regard to those segregated groups. Risa, do you have a microphone?
I do. Can you hear me?
Thank you.
Well, I'd like to know from Grace if she's representing the 53 and all they want is what we want, then why is the Barker group going out and asking people to join the 53 to carry more votes? That just doesn't make sense. And that is the true statement.
Group 2, and I had mentioned earlier, for the most part, I cannot speak for all of them. Because I don't know at this point, because I didn't know even coming to this meeting today what it was about. So I prefaced my remarks by saying, I'm Grace Good Eagle. And in that sense, I represent the Good Eagle family. This is the way I feel. Now, I can't speak for the others on group 2, but when we do group to get together, because our initial thought too with starting discussion, let's get the money first. Then we can do more about distribution.
Thank you, Grace. There's another question.
Hi, I'm just wondering if perhaps there are others of the 53 who are under the impression that or concerned about the equal distribution of the money. If that's truly the concern and why they're part of that group, can the tribe reach out to each of those 53 people and just clarify, hey, that it's going to be equal distribution based on the September 2019. You have to go through your lawyer, so then they might not relay that information to them. But if they were here and hearing what you're hearing and knew that that was never an issue of concern, that it was always going to be equal distribution, including you all, maybe there wouldn't be a group of 53.
Has the business committee had a meeting with the 53 to figure out what they're even asking to address kind of what Cuggy said? There's a lot of innuendo and kind of rumor and conjecture in here about what the 50 has the business committee met with them or met with their legal counsel to determine what they are even asking for?
We have not met with their legal counsel yet.
I have a question or a comment. The rumor mill or whatever has left the impression, this is the impression I've received, let's put it that way, that the 53 want the entire amount of money to themselves and the tribe gets zero. That's the impression I've gotten, Grace. And it's sounding, I'm hearing more from you that it's not right. I don't believe it's right. The damage that was done to the tribe through the years, many, many years, was damage to every member of the tribe. So when the judgment came down, I remember my mom saying, I wish my grandma was alive to see this, because she suffered so and had so little. And she says, that's who I want to see that. Well, every member of the Quapaw tribe is a representative of grandma, of their grandma, their great grandma. We are the tribe. And now more than ever, we have to stick together. And if we are awarded a judgment, it goes to every descendant of the ones who suffered the damage. That is only the fair and equitable, I think, that's according to me, solution that every person, and when and if we ever receive that, we need to remember the cost that it came to. And we need to love each other and quit picking at each other, right, Grace? And stick together, because trust me, there are fewer and fewer people that are going to stick together. We've got to do that part. And if it's come down to you're worried, the Good Eagle or the 53 are worried they're going to be excluded from that, I don't know how many times I've heard many, many people say equal distribution to every tribal member. Now, I don't know how you can take that any other way, but the impression I got was that the 53 people wanted that all to themselves. No. So I'm glad I'm here for that very purpose. But we have got to come together and decide what is going to be the best for the tribe. And while I got the microphone, I'm going to suggest, I think it is an important suggestion, that all the minors have their money put in a trust so that when they become of age, that will be theirs. That's their little nest egg to get started in life. And too many parents cannot be trusted to handle that amount for their children wisely. So that would be my comments. Thank you.
Thank you.
Thank you.
I think that was a great suggestion, Lois, and definitely something that I'm hoping is going to come out on September the 30th, really regarding, because even in the 1954 Quapaw Indian settlement that's referenced in our governing resolution, the way that one worked, it was, I always thought it was at age of 18, and then I found some other documents that led me to conclude, no, unless it was a hardship where the Department of Interior could be petitioned, they weren't eligible to receive that $900 until reaching the age of 21. Like they could use it earlier if it was for education, medical, probably a very short list of items, but it's the same concept that's spot on. There's another question?
Grandma Grace, I don't mean no disrespect at all, but was you guys given the choice to stay with the tribal lawsuit or break off on your own with the other law firms?
Let me have your question again. No. We want to work together. And no, we don't necessarily want to be on our own, but the 53, we disagreed with the handling by the law firm that was representing the tribe. That's why we chose our own legal counsel. Right. But even so, again, unfortunately, based on a rumor, then there was concern. But we're all Quapaw.
Okay, so they decided to break off on their own originally from our tribal lawsuit, which all of the rest of us were asked to do too. And we said no. We wanted to stay with our tribe because we believed in our tribe to give us our money. And if our September 30th meeting is just for our group, our go to make a motion to, if they decided to break away from our original lawsuit and do their own, why can't they go through their own litigation steps and get their own money?
Has it already settled January of 2020?
So we can't just like
Lawsuit is
take
over.
so both things have to be in agreement now.
Mm-hmm. Yeah. Just to get Congress to introduce a bill
Okay.
and hopefully get it through.
Okay, so as long as that group isn't agreeing, I mean, Grandma Grace says, you know, she wants it all, but the others don't. So as long as those two groups ain't agreeing, then it's just on hold for everybody else. because those 53 that broke off from our
And,
original
and I
one.
think that's why it's important, and we will indeed be meeting with, legal counsel that represents that group two. We do not want to do that before the special general counsel on 9:30, though.
Is that going to be an open meeting for tribal members to attend?
No.
Why? I mean, obviously, we're part of the lawsuit, are we not?
It's a great question, to be honest with you, and I'm thinking, well, maybe we should, but our understanding of what
can
at
we
least the
implement
legal
that?
representative wants is not a full and equal distribution. Our impression is that the distribution would be basically through the Department of Interior based on an allocation scheme that was utilized by Plaintiff Group 2 for the Good Eagle distribution.
Yeah.
Which means based on those formulas, at least what I've seen, means if you don't have land, you're not getting anything. And if everybody got $5, that'd still be an equal distribution, wouldn't it?
Yep.
That's not acceptable.
So you guys are actually going to meet with them, but is there a way that tribal members could input questions to you guys since it's not going to be an open meeting?
Of course, that's what we're here to do. We should be available and open to all tribal member input at all times, regardless of the topic.
Okay. All right. Thank you.
If I could, I'd like to make a comment. I appreciate that comment that you said about putting the young people's money in a trust. I'm one of those that was back in that early payment. If it was not for that, I'm sure that my parents would have been in a dire strait. My dad was in the United States Air Force. We had 4 kids, and it was difficult in that time just to try to take care of school clothes. My mother would write a letter to the superintendent to get money for school. So that took a great burden upon my dad's shoulders. So, I'm just one of the individuals that can be able to say, we looked at it back then that, $900 back then, it was $900. Now today it's not worth hardly anything. But today, if we can come to a consensus, that's what we're just trying to do, is give you the facts of what can and cannot be done. If we can come to a consensus, it sounds like, I know that Grace is talking that, hey, we're talking all Quapaws. We are all Quapaws. Yes, the Good Eagles have been settled. Maybe they'll get a little bit there, but the all Quapaws at least get it out to families that need it. Cuggy said it, that the attorneys for the other group, if it got settled in their direction, what is it, 40% that the attorneys get?
Yeah.
40, about fit, yeah. That's a lot of money that they're getting. Yes, naturally, if I was an attorney, I would be fighting hard to try to get you to go this way because I want to get paid. So that is just something to think about. It sounds like we're at a pretty close area that we're talking about all Quapaws. We're not trying to exclude a group. We're saying Quapaw.
On
Any
Zoom,
other
we have-
questions?
Yes, on Zoom we have Kelly Flanagan who would like to speak, and she's claiming to be another member of Group 2. We're asking to.
Hello, good afternoon.
Hi, Kelly.
How are you guys?
Great.
Other than being in a heated argument. Yes, just like Grace, I am in Group 2. Now, as I recall, and Grace can collaborate with me on this, at one of the general council meetings, when John Berry was the chairman, he called together all the plaintiffs who were in the Good Eagle case and told us that we needed to opt out of the COBEL so that we could opt in to the Good Eagle. And that was because we were descendants of landowners. I'm a descendant of Anna and John Beaver. So yes, I am Quapaw blood. So Connors and Winters were the attorneys. And when they, at first everybody was on board with those guys, and they were better than a damn slice of bread. Then when they sent out the letters to tell everyone what their share was, then that's when the discrepancy started. I have a younger brother who's 11 years younger than me, and the reason they said he was going to get more money than myself or my uncle, Thomas Charles Bear, was because he had his IIM account longer with less money passing through it. So that is one of the starters of why Group 2 got their own attorney, is because we needed to look into that. Because somebody who's in their 60s at that point has had their IIM account for several years, decades. I'd had my mom died in 1977. That's when I got my IIM account. But yet, those of us who were older were getting less money, and it seemed suspicious going through Connors and Winters. So that is when Group 2 hired their own attorney, and who did their own calculations, who gave us a better settlement than Connors and Williams, or Winters, whatever their name is. The Bear case was filed on the pretense of damages done to personal property for zinc, lead, and mineral damage that took away their agricultural grounds, which eliminated all the small game. They could no longer hunt, they could no longer plant, and filled up their land with chat. And who do you think most of those landowners are? The Group 2 people. I don't want to hear you guys beating up on Gracie, because Gracie's an amazing woman. I just want to put this out there because I'm tired of everybody thinking, yep, if Group 2 gets 40 or 50% of that settlement, that's because we were landowners. Anna Beaver, John Beaver were landowners. Beaver gave the tribe the powwow grounds. So if the tribe gets $5, like you referenced, or if they get $30, if your personal property of your descendants wasn't decimated by zinc, lead, or minerals, then, that's what the whole case was about in the beginning, before you started trying to take out the word landowner, and because you wanted to do this and you wanted to do that. That is why this case has taken so long. I'm sorry if I'm sounding hateful, but this kind of gets on my nerves. And don't pick on Gracie, because Gracie's a good woman. And yes, Connors and Williams chose to use her name for the first case because it sounded more Indian than the rest of our names. And that is what they told us at that general council meeting, and I can't even remember when it was. It was like 2011 or 2012, something like that. So that is why the case is called Good Eagle. And my uncle, Thomas Charles Bear, is the one who filed the Bear case. So, yeah, I'm all for everybody getting some money out of it. But if your personal property didn't have zinc, lead, or other mineral damage, aside from water, then I think our descendants are due that money. And yeah, me and my family are in Group 2. Thank you for your time.
Kelly, thank you for your comments, and I can assure you that that Miss Grace is being treated with the utmost respect and care that one would expect of an honored elder. My apologies if it's not coming across that way on Zoom. So I do believe we're getting into the debate phase, which is best left for September the 30th. Might there be other questions in the room? Roman?
Thank you. So you stated that you received correspondence from Group 2. Is that able to be shared with us, what that was about?
Let me take a look at it, because I don't remember it saying anything a whole lot other than just, we want to meet with you guys. And since that time, yeah, we just got it recently. It was just referencing trying to get together to sit down and have a discussion. And the only thing that's been communicated thus far is we're happy to do so, but not until after the special general council on September the 30th.
Okay, thank you. So that seems kind of, the cart before the horse, in my opinion, just because I want to be able to make a decision based on what the plaintiff group 2 is asking. And
Plaintiff group 2, those are important, that group 2, those are important questions. But that is separate and distinct. And that's the reason I was adamant the special general counsel had to occur before meeting with, some other legal counsel. The Quapaw people's will is the only thing that matters. Legal representatives of other, smaller groups, that's fine. We can listen to them. But they do not speak and act on behalf of the Quapaw Nation. We need to understand exactly what the will of the people is to ensure that we are behaving in a fashion consistent with that. That's the reason for at least our view on the appropriate timing.
Okay, I understand that. Thank you. The second thing is, can you clarify? So we talked about, or we heard about HR 5852, which really blew through the statute of limitations, which to my understanding goes back to the establishment of our reservation, which is well before.
Earlier, it goes back to 1818 and the unfulfilled treaty obligations that the government never came through on.
Okay, so even further. So almost 60 years before allotment even took place.
Correct.
Right? Okay. Do we know what those damages were that were taking place before allotment, before there were even any landowners, when the Quapaw Nation was the landowners for everything?
It's a great question. I've had I've long pondered the same thing. We know anecdotally, and this is part of what we're asking RSM and Hobbs Strauss to look into carefully, but I know anecdotally we had heard previously that there's not a single treaty that we ever struck with the federal government where all of the terms were fulfilled. Some of the treaty, whether it's 1818, 1824, 1833, there were payments, and they could have been not necessarily money, but goods that were required to be provided to the tribe, that the federal government could never produce records to prove that those treaty obligations were completely fulfilled. Then there's a component of, in some of the documents that are in there, I don't know if I included all of those, but a big part of the settlement negotiation had to do with, okay, well, we were supposed to give you, I'm making this up, a bale of hay, right? But a bale of hay in, let's say, 1824, and then you do the future value of what that bale of hay was, and my apologies, it's a bad example, but what is the current day price associated with what should have been delivered in 1824? Now you're bringing in components of time value of money. The Justice Department disagreed. They argued over it for a prolonged period of time. And then that's the reason in some of the final documents, there's an extensive discussion about what the federal government is required to do when it comes to safeguarding the assets and the highest and best use, especially from an investment standpoint for any monies that they retained. So they brought in the time value of money, which is the reason that the Bear settlement was so much higher than Good Eagle. That was bound by the statute of limitations. Bear was not busted through. And it got, introduced as basically a reference where we gained an entree into the U.S. federal court system because they have to give us, because they are sovereign immune, they're sovereigns as well. They had to grant us waiver, at least limited waiver of sovereign immunity to be able to introduce that lawsuit. So yeah, that time value of money is a big component of the calculations. That was my understanding, Roman, and I'm hoping that RSM and Hobbs Strauss are going to find even more telling kernels of information that'll make it easier for I think all of us to understand what were the underlying tenets of the suit and why was it so tremendously different in comparison to Good Eagle.
Thank you.
Brenda, I think you had a question.
and the Buffalo descendants weren't on the group two. So it's, I mean, it wasn't just landowners, and we were a large portion of the landowners.
Right. And we know there were a lot of people who, if we think about the allotments, in 1890, we all descend from somebody who was on the 1890 census, every single one of us, and some of us to multiple. So, and if we carry that forward, it is interesting in terms of the way a lot of us have seen the maps, or we all love looking at, where our great grandfather or our grandmother's land really was, or maybe even still honored to live there to this day. We know that there were allotments, that there were no mines, there were no minerals, yet it's covered in great big chat piles, and the land has been deemed useless and still has to be remediated and still has heavy metals in it. So it's not just associated with the mines, it's also associated with unfulfilled treaty obligations going back a couple hundred years. All of this goes into this morass. We also have to acknowledge that land ownership, if we all descend from someone from the 1890 census, which I know we do, and presumably the land allotments were consistent with that a few years later. It wasn't that much later than that. So, and we all got land. We know that people lost, got swindled, their land stolen, so on and so forth, meaning who owns the land today is not indicative of who owned the land in 1895. And lots of crazy changes have taken place over that period of time. So, that's when we go back to we all descend from multiple generations of people who suffered. And to say that current ownership somehow defines that suffering is very troubling.
And some of us did not have a choice in our life to own any original family allotment land. Some of us weren't. All of the land had already been sold by the time some of us were even born. So the way they speak about land owning, I never had a chance to have any of my family's land. My name is not on anything in my family, and we have a big family. Although you'll find certain family members who have the names and own what's left, some of us didn't have a choice like others. So I don't understand that part when I was spoken earlier. But I do want to thank you, Grace, coming over here in person, knowing good and well that being a part of the group 2, all kinds of different questions and comments would be directed towards you. It's very admirable. And Kelly for speaking as well. Because there for a minute, kind of, you know how these things get. They kind of just pick out one person or two people, and it's kind of a fish fry sometimes. So I'm glad everybody was generally respectful, and I just wanted to say that, comment that much. I sure appreciate you coming out in person. I don't know who else is on the 53 because I've never seen the list myself. I just know there's another group. So to sit there and speak up for yourself of being a part of that group, that's not something lightly done in a room full of people who are wanting equal distribution compared to another group who are wanting it for themselves. So I just want to say that much to you. Thank you, Grace.
I had a few questions. From everything I've looked at, the only breakdown of what claims that were being pushed came from the tribe, and that came out to like $5.8 billion. Have you found anywhere in the settlement, the eventual settlement, where the government gave a breakdown?
The only breakdown I've ever seen is in the total amount allocated for a combination of Good Eagle and Quapaw, which was $59 million for Group 1, and then the $137.5 million.
Okay,
Bear.
so yes,
there's I've never seen. I know that people have thrown out amounts of money over the years for Quapaw v. U.S. I've never found a court document that did that. I've seen one-off analyses, and I know not if the data that they were basing that off of, I don't know what they were basing it off of. But the court. I've never seen anything in the court documents.
So that's I guess kind of where I was going with that is from what I've seen, and I've read every single opinion piece I can find on Bear. The government never gave a breakdown of who got what. The tribe asked for it. The government's response, their argument was, some of these things we think are bogus. Other things we already paid you for in Good Eagle, but we're going to give you 137 million to just end this. We don't argue over it anymore. And Judge Wheeler, in his opinion, also stated this goes back 200 years. Was his words. This goes back 200 years prior to land allotment, right? And in his ending statement, he says, for any and all claims that have been or could have been. Those are his words. So I agree that I think it's more complex than just land. It has a lot more complexity to it. The second thing to consider is Lawhorn. How does Lawhorn, which, as many of you know, was the decision that upheld our reservation, said our reservation was never disestablished. The reason that the state's argument for disestablishment of reservation was that, well, you guys all allotted the land. So how would that play into the settlement in the end?
Was that a question?
Yeah.
I'm sorry.
Sorry. How does Lawhorn play into the settlement or the appropriation of Bear? With it, with our reservation never being disestablished.
Yeah, I don't see an intersection because the settlement was reached January of 2020, really prior to the Lawhorn decision coming through the U.S. Court of Criminal Appeals. Maybe there is an intersection I just don't recognize, but I don't see it.
Thank
But
you.
I'm not a lawyer either, so I think we've gotten to a good point. I think we've received really good input on some improvements that we can make to the frequently asked question document. We'll get those updates made tomorrow, make them available both on the tribal website as well as social media. The last component is we may actually have an opportunity in time to get that FAQ out in the Quapaw Post as well. I'm not going to, the U.S. mail sometimes takes longer. So with that, I would ask if.
Mikkel, do you have a question? Mikkel has a question.
Oh,
I'm sorry.
I didn't know if you were stretching or not. I wasn't sure. I'm sorry.
Stretch today because not much sleep. I have more of a statement, but it's also a question, but less for the board and for our community. This here is just a fever we have of a greater poison. For over 300 years, our communities has been sabotaged. It's not any one group, but systematically, our culture has been demolished. And we have been turned against each other over and over and over again. And even recently, we have had events that have caused us to undermine our trust in one another. So it's inherent now that we have this poison of mistrust in each other, that we all feel that everyone else is just trying to take from ourselves for themselves. So I want everyone to ask you that question. When we sit down to the discussions, am I just being poisonous? If we want to make progress in this, we need to sit down in good faith. Keep that in mind over these next couple of months.
Thank you, Mikhail. Let's close out the meeting with a prayer. Amy Panther Kvistad, would you mind terribly leading us in prayer? Thank you, Amy, and thank you to everybody for participating this afternoon. Look forward to September the 30th.